This is session 1 of about 8 sessions, and today we are going to be looking at the legal ramifications for young people in this particular time around COVID-19. And basically what we wanted to do, we appreciate that at this moment in time, when it comes to working with young people and families with COVID-19 coronavirus, it's very, very tricky. So what we wanted to do is try and bring some of the best practitioners across the country together to just give you best practice, their ideas, what they're doing and what they're working. And like I said, this is the first of 8. They're only going to be hour-long sessions because we appreciate everybody's busy. But today we have got Augusta from Just for Kids Law. I'll let her introduce herself in a moment. I'll just give it a few minutes before we start because we know that I've got probably about 200 people who have booked up and people are coming in slowly. We've currently got about 60 people. So we'll give it a few minutes before we start. And yeah, I'll just introduce myself. My name is Ben Lindsay. I am CEO of Power to Fight. We empower communities to end youth violence, and we have been going since 2019, even though I've worked in this field for almost 20 years. And what we want to do is try and give a community response to youth violence and look at the systems. And one of the things that we do is that we believe if we can equip and train all different parts of the community, we have a better chance of trying to solve this issue. So one of the things we do is workshops and conferences like this. So yeah, we'll crack on in a minute. Augusta, do you want your slides to be like that?
No.
If you just go to, yeah, if you just do it like that, I think that's probably a better way of just going about it. Then you can just click.
Yeah.
Is that okay?
Yeah, absolutely.
Cool. Okay. We'll give it a couple more minutes and then I'll let Augusta introduce herself. Just to let you know, we are a charity. This event has been able to be run through the City Bridge Trust. And so if you're feeling like you'd like to donate to Power to Fight, you can go to our website, powertofight.org.uk, just hit the donate button. And yeah, any amount of money would be helpful for us to continue the work that we do. As I said, we develop training and workshop for anyone who's front facing with this issue. We develop resources such as our Power Talks, which again are short interviews and podcasts for anyone who's front facing with this issue. We support families, so any families who've been impacted by youth violence, we have financially supported over 15 families in the last 2 years. And the final thing that we do is that we are currently developing a culturally competent therapeutic service for young people and families who don't necessarily always get to engage with therapy. So if any of those things you feel like you'd like to support financially, we would be much appreciated. Okay, I think we'll start because it is 1:36. Now, I've seen your PowerPoint, you've got a lot to cover. So I'm going to hand over to Augusta, who is going to take you through. And then what we'll do at the end, what I'll say actually, just to say that if you've got questions, put them in the box, in the Q&A box, and we'll have some time at the end to make sure that we can answer some of your questions. So don't be afraid to do that. And then we'll have a bit of Q&A with Augusta at the end. So Augusta, over to you.
Hi, everyone. My name is Augusta, and I am a youth justice lawyer and policy educator. Prior to that, I was an advocate, during which time I gained quite a lot of experience just working directly with young people. For me, after a while, it just felt like the natural progression was to move to qualify as a lawyer and then as a youth justice lawyer. Today, I just want to, the topic of today is legal ramification of COVID for young people. I apologize in advance if there may be occasions where I use the word children. For the sake of clarity, a child is anyone under 18. So just for Kids Law, we work with people between the age of 10 and 25, which requires us to have both expertise in children law, like criminal law relating to children, but also relating to adults. But there are times where I use this word interchangeably. You have my email. The reason I put my email is also because we do run a national advice line. I will go on in a minute to talk just briefly about Just for Kids Law, but we do run a national advice line. So if there are any things that you want to ask about, feel free to drop me an email, and we are happy to provide, any specific. I'm happy to respond to any specific question you have, which you might feel that we can cover today. So Just for Kids Law was set up in 2007. And since then, it's developed what we like to refer to as a holistic model of representation. It was founded by Shonin and Aika Stevenson and Shonin Lambe, who were both lawyers. Aika specifically came from a very youth justice background, having worked both in prisons, but also as a youth offending, and also in the youth offending team. One of the things they realized quite soon after founding Just for Kids Law was the fact that quite often, especially when it comes to criminal justice, young people have a variety of issues going on in their life. And until you kind of deal with those issues at the same time, which obviously is not always possible because young people may not be ready or at that stage to deal with other issues. But I think what they really developed was an idea whereby a lawyer or an advocate needs to be aware of all the legal issues or all the different issues, even if they're not legal, that are going on in a young person's life. We do have several legal teams actually. So we have a legal team that covers immigration and asylum matters, criminal law, community care, housing, and public law, which is anything to do with a public body. Whilst we have all that expertise in-house and our advocates have access to that, we also have an advocacy team because there are things that might not be strictly legal, which the young person may want assistance with. And lately, in the past few years, what we've added to that package is a youth teams, which if the young person is willing and happy to take that further step and try to get employment or engage in a positive activity, they can access all of that in-house. Because one of the things we found is the young people, especially when they have to engage with many different professionals, they may struggle with that. In the more recent years, Just for Kids Law has developed different areas of work. So there is Just for Kids Law, and then all the different other brands you're seeing are different brands of Just for Kids Law. One of them is the Children's Rights Alliance of England, which is a membership organization that monitors the UN Convention on the Child Rights and makes sure and reports and monitors and makes sure that the UK is abiding to these and the obligation under these. We also have the School Exclusion Hub, which was developed by one of our education lawyers. And the aim of that, because we're very much aware of, how the current state of the education system is in England and Wales, and that's very concerning. Also, one of the things we have found through our work, but also through a lot of research that is available out there, is the fact that quite often exclusion, education exclusion, and even social exclusion is very much linked to a young person going into entering the criminal justice system. And quite often we find a correlation between young people being excluded and then later on entering the criminal justice system. So, but at the same time, if any of you have ever needed to access an exclusion lawyer, you'll be aware that they're incredibly difficult to access. There are really few organizations in London and actually nationally that does this type of work, especially because it's not legally funded. So the Exclusion Hub tries to create an online resource which professionals as well as parents can access, so including templates, letter, and so on. And then through that, they can do some of the work which they might not be able to get support with doing if they can't access a lawyer. And then lastly, there is the Youth Justice Legal Center, which is mainly the branch of organization in which I work in and also the criminal team works in. Some of the key things that the Youth Justice Legal Center has and does is trying to recognize and get the attention of policymakers and so on, that there needs to be an expertise in youth justice. There are many occasions in which young people are represented by other criminal lawyers, and whilst of course the knowledge is pretty much the same, actually I will correct that, whilst of course a criminal lawyer can have knowledge of the adult system, there is a whole range of additional support actually that is available for young people. I'll talk about this later on today, but they're just like a whole range of different type of diversion out of the criminal justice system, or restorative justice approach to criminal behavior that actually are accessible to young people. And if a criminal lawyer is not aware of that, or even magistrates, then the outcome for the young person can be significantly different. Besides, being a center of excellence, we try to also be, we also try to do training. We also try to host a yearly event where we invite professionals from different sectors, especially from psychologists and psychiatric background, because quite often our clients happen to have diagnoses including autism, ADHD, and so on. So actually we find that working with them especially to bring this narrative to the courts, to understand how the adolescents' brain development works, and how immaturity works for children, and how children should not be criminalized for behavior that's for something they commit when they were children. So that's just a forum to have this conversation happening. And lastly, we, on top of taking criminal cases, we also run an advice line which is free and is accessible to young people, their parents, and professionals. So enough of just for case law now. So I appreciate the topic today is about the legal ramification of COVID. However, it felt that I felt it would be quite difficult to talk about the legal ramification without just having a quick overview of what the new legal instruments that have been introduced are. Quickly, I would just say that throughout this presentation, I am primarily going to focus on the offenses that have come out of the regulation, and I'm going to focus on the powers, but there is also a regulation that I'm sure some of you would have heard about, which actually is part of the coronavirus regulation, but there is a whole section and schedule that refers specifically to children in care and look after children, and how the regulation actually brought a whole range of provisions that were arguably discriminatory towards them. And I know many organizations, including ourselves, have been doing a lot of campaigning around that, and there have been some outcomes, and quite recently this matter was brought up in Parliament. I'm not going to go into that today, firstly because it's ever so evolving, because of all the organizations that are actually actively campaigning about how unfair it is to limit, for example, contact with social services, or access to certain provisions for children in care or caregivers who are already particularly vulnerable. The second reason why I won't go into in depth into that in its own self, like a whole other presentation. So I'll just focus on the two new legal instruments. So primarily, two things have been brought forward. So one is the Act, so the Coronavirus Act, and the other is what I will refer to as the Coronavirus Regulations. Technically, there isn't one. There are, I think, at least four, but I think three of them are the ones that are more commonly known. There is one that was brought upon very early on to deal with the closure of businesses. So if you remember the first announcement Boris Johnson made, that was with regards to the closure of pubs and so on. So that was the business regulation. And then there was the health regulation, which was more focusing around restriction of movement, seeing people, so not being able to see, to go out or to go to exercise too often and so on. And then more recently, parsons to, I think, Boris' last announcement on the 12th of June, I think new regulation were brought forward, which are specifically around the use of public transport. But the key thing, I think, is to just bear in mind the fact that these act and regulation, these new legal instruments apply to both children and adults. They create new offenses and they bring about new police powers. They also enable the police to use reasonable force to make sure children and young people and adults are complying to these new instruments. But also, one of the things which I hope we'll be able to talk more in depth later on is the fact that they do bring a risk, especially for young people, to be confronted. So they bring a risk whereby before we all know about stop and search, we all know about different stop and account, but what at least I have experienced, my team has experienced since the bringing power of the regulation, is the fact that there is now an additional reason for stopping young people. And what that means is that then when that happens, quite likely there is always a follow-up offense. So we've noticed, for example, quite often a young person being stopped, especially very early on, for being outside of the premises, especially when this was not allowed. And then when they were stopped, they were searched and they were found with possession of cannabis. And then that was a subsequent charge, or sometimes with an offensive weapon. Or actually, sometimes we've had also young people, quite sadly, who, for example, have health conditions. So they are being arrested, they're being taken to a police station. And generally, I think, especially when there was so much panic and anxiety, and I think one must not underestimate how children and young people react to anxiety. When they were being brought to the police station, they were then reacting, and they were then like trying to almost fight back to some extent, although not physically, but just to challenge the police. And that has led to like charges, for example, of assault or racially aggravated insult, all sorts of secondary charges, which effectively means that children now are ending up being arrested for other offenses, because quite often the initial reason why they were stopped, so in relation to a possible breach of the Coronavirus Act and regulation, is then discontinued. Nothing is done about that, but then they still have another offense. So, and lastly, I think one thing that I think is going to be quite a recurring theme across this whole presentation is the fact that look after children, caregivers, and Black, Asian, minority ethnic groups, being children and young people, they already are disproportionately impacted, and they're also, their representation is already disproportionate within the criminal justice system. So what this has meant, it means that now they're even more disproportionately impacted, and which is also further aggravated by the fact that BAME children and young people and generally BAME communities are disproportionately impacted by the Corona Act and regulation. So before I move on to what the new criminal offenses are, I think it's important to just take a minute to appreciate the fact that since the coming in force, I think officially on the 26th of March of the Act and the regulation, there have been many amendments. So there was one on the 22nd of April, and then another one on the 13th of April, then there was another one on the 1st of June, and then finally two subsequent ones recently on the 12th and 15th of June. What that is simply, what it means is that every time there's been an official announcement and a change in the government position, that has been reflected, although the change in the act will probably happen before the announcement to the public, by a change in the law. So the reason why I just added this slide was just to maybe focus on where we are at now. Things have changed a lot. They've changed significantly. So initially there were a lot of things that were prohibited. However, now there are mainly only 3 prohibitions as of the 1st of June. So the first one is to stay overnight at any place other than where you live without a reasonable excuse. I've highlighted linked household and without reasonable excuse because those are things that are defined in the regulations. So linked household is where an adult and there can be multiple children, but at least one adult makes a decision to go and move with a different and live with a different household, but subject to everyone in the other household agreeing for that person to move. It does sound a bit complicated, but there are situations, especially with children and parents who are living far away from children, or separated parents, where this does make sense. In terms of reasonable excuse, there are a number of reasonable excuses within the Act. I'm more than happy to circulate this presentation because I've added it in my notes. But it's easy to just, for me as a lawyer, I would say it's easy to just go to the regulation and just look at it, especially with the frequency that has been changing. But just generally at the moment, it's best to just assume that there is no, overnight stay. Just to give you a few examples of what the reasonable excuses are, some include the staying overnight for voluntary work or charitable work, in case of an emergency, in case it's unsafe for you to stay where you are, or to attend a funeral, but that's only if you are a close family member, and the list goes on. The other prohibition that there is as of the 1st of June is to gather outdoors in more than 6 people. Although not many people know about this, but actually you are allowed to gather in not more than 2 people, so less than 2 people indoors. The exception to both of these is when you are gathering with someone from the same household, and or someone from link household, or where any of the exception apply. One of the exception, again, the exception are very similar to the exception in the reasonable excuse one. However, there are a few more exceptions to include, for example, visiting someone in a care home or visiting someone in a hospital and so on. But like I said, I will be sharing this material. And then more recently, I actually think this is as of the 15th of June, so pardon my error there, but it is now a criminal offense to wear a face mask, to not to wear a face mask in public transport, unless you have a reasonable excuse. And again, there is a list in the regulations. And just to give you some example, I think children under the age of 11 and children, and to eat and to drink, you can remove the face temporarily, or a police officer in execution of the duty. So there are some exceptions, and again, I've included them in the list. The reason why I just thought it was important to just talk briefly about the criminal offenses is because one of the things that sadly has been happening, especially since the 23rd of March, so since the lockdown started, is that people, especially children and young people, they I think, we can all appreciate that there's been quite difficult and vague communication even from our leader, but quite often the police don't know what the rights and entitlements are or what the offenses are because they change so often. The parents don't know this, and neither do the children. So there have been situations where actually there was no lawful reason to be stopping someone. And considering where we were when this all started on the 23rd of March, we've actually gone quite a long way. But I wouldn't assume that police officers, some of them, are not mistakenly stopping and searching and detaining and arresting children and young people just because they are not necessarily fully clued up of the regulation. And I think we can all appreciate that it is challenging for a young person to challenge this, but even so for a parent if they're not fully aware of where they're standing. Briefly, I will just go through some of the powers. These have pretty much been the same since, although there have been some minor modification. So there is a power to arrest, to maintain public health and public order. So this is just an extension of a power of arrest that already existed under the Police and Criminal Evidence Act. And then one of the thing that's actually been interesting, which has been added by the regulation, has been the breach of peace powers. So again, when making an arrest to maintain public health and public order, the officer may determine whether or not to also conclude that there is a breach of peace powers. So, and again, all these terms, I'm sure they sound vague, but they are that vague in the sense that they should not leave room for interpretation, but sadly they do. And so again, quite often we do find young people being arrested. In terms of the power of the breach of the peace power, what is particularly problematic about it is that you cannot be charged for it. So with most offenses, you can be charged with an offense, but you can't be charged with the offense of breach of peace power. However, you can be arrested. And what amounts to breach of peace power is when, for example, you appear in the process of arrest that you are going to cause any harm, or you're threatening to cause any harm to a person or to an object. So that's really vague. And also what that means quite often in practice is that children and young people, they're being arrested, taken to police station, and then quite often actually they're not even taken to a police station, but they're just released, because that's what the breach of power, peace powers are sometimes used for. But again, that is incredibly problematic, because besides, you know, the implication of having a criminal conviction and a criminal charge and having to go through the criminal justice system, there is also the negative implication of just being targeted by the police, but also having that contact, which sadly is not as positive as we would wish for it to be. I'm just going to quickly wrap up because I'm actually aware of the time. Yeah, and so on top of all the different powers which you have seen in this slide, there is also like a power to in relation to potentially infected person. And as things stands, everyone right now is a potentially infected person, because there is again a very vague definition, which involves anyone who has either tested positive, who has tested positive for COVID, or anyone who has tested, but the result has been inconclusive. So many people are not currently being tested. So unless you've been tested, you could be a potentially infectious person. I'm not going to focus too much, again, bear in mind of time, on the regulation breach, but effectively, in summary, you can be given a fixed penalty notice as an adult, which is really well fine for most people. However, this is a huge problem for anyone under 18, because technically there isn't the possibility, you cannot issue children with a fixed penalty notice. So that is a huge gap that we've been asking to address, but it still hasn't been addressed. So let's move on to the legal ramification of COVID. So there are quite a lot. However, I'm going to focus to, I'm going to just quickly go. There is the issue around appropriate adult. So without going into detail of the technicality of the law, but there is an issue around the fact that children in breach of the COVID regulation, especially those actually technically the Coronavirus Act, so anything relating to a potentially infected person, they can actually enforce those power, some of them without the presence of an appropriate adult, and some of them there needs to be an appropriate adult. So what you then, but the police can decide the most reasonable person in that moment that can be an appropriate adult. So that's of course like really problematic. Sorry, we just had a, yeah, sorry, I was just looking at the chat. And then there is also another issue around unaccompanied children, which is very similar to the appropriate adult. So again, the regulation does talk about some of the powers that apply to children when accompanied by an adult, but then they don't go and specifically refer to what are the implications for children, which quite often happen, who are out and about by themselves. Again, there is the issue, like I was just saying, of the availability of the fixed penalty notice. And the issue with that is that due to their not being available quite often with adults, what would happen if you're breaching, even though it's really hard for you to be fined in light of how they've changed, the powers and the breaches and the offenses have changed. If you are stopped as an adult, and the police really should not be fining you, but even if they decide to do that, they can just do that on the spot and there is no need to arrest. But because they can't do that for children, what that means is that quite often they do end up getting arrested. I will not specifically talk about this, the remaining of the issue. So arrest and detention. I'm really sorry about the amount of data, and I'm not going to go into it, but what this data is just showing, and what I was saying earlier, was the fact that children and young people, children in general, but particularly BAME children, are disproportionately stopped and searched. Just to give you some numbers, 15 to 19 years old between 2017 and September 2018 were the largest age group to be stopped. And then specifically since 2009, which is the earliest year there's been data available, until 2019, they normally just compare the data on every couple of years basis, Black people have been consistently stopped and they've consistently held the highest rate. We regularly make subject as freedom of information requests. So for example, we made one just recently, and in the year ending 2019, March 2019, there were about 60,200 between 10 and 17, and BAME Black children were 4 times more likely than white children to be arrested, and generally BAME accounted for 29%. Similarly, and this is actually quite tragic, just in London alone, in 2019, in the whole year, the Metropolitan Police arrested 7,000 children. 67% of those were BAME. So just this morning, actually, The Guardian released an article confirming that the police enforcing of the coronavirus lockdown regulation act has resulted in young people being, and Black people being more than 6 times more likely to be fined for Black and Asian minority ethnic group. And that's a freedom of information that was made across 17 forces. So I think what the gist of what I'm just trying to say and show here is that it was already bad enough, but now it's just getting worse. And that's something I think that we really need to think about. And I will give some suggestion about how to do that. So again, here I'm just throwing some data at you, and again, the gist again is that one of the things that has come out of this regulation actually is that there is a reference to the use of reasonable force in enforcing, in exercising the power conferred by the act and the regulation. Whilst this may seem as something that is understandable and required, it is something that, at least to us as a children's charity, is been creating us a lot of concern, because we were already doing some work prior to this about the use of taser and spittoon on children and young people. And again, this is disproportionately used on children, and more so on BAME children. And what we worry about is that because there is actually a provision for that to be used, already you could question that, because you could question the necessity to use that, or you could question why was there no provision to actually differentiate between adults and children. So have the provision of use of reasonable force for adults but not for children. But even so, even in the case where there is a decision not to use reasonable force, we do worry this might result in the use of taser and spittoons as distance control measures, especially officers who don't want to contract the virus and so on. And this already disproportionately impacts BAME children, and it will definitely impact them even so more. So one of the, I think now we're actually moving from like children towards more young people. So one of the things that the COVID, I think, is really showing, and I personally don't think is quite visible as yet, is the delays. So crime don't stop and things keep happening, and the courts have been closed and they're trying to reopen now, but that just means that there have been massive delays, especially over the couple of months, and that's a huge issue, especially when you're talking about young people and children, so anyone up to the age of 25, for whom a month, a year actually is a really significant time, passage of time, and there is sufficient guidance from the CPS, the Crown Prosecution Service, that actually this gap should not be happening, because the longer of the gap you keep, the harder it's going to be for the child to relate to that offending. So I saw, oh, sorry, I'll answer the question in a moment. So one of the things I just wanted to quickly touch on was turning 18. Oh, yeah, turning 18 during COVID. So turning during 18 during COVID, what that means is that a lot of young people, generally, I think just before COVID, there was a lot of news on the media about the delay. And I don't know if any of you have worked or been in contact, or is a parent or is a young person whose matter has been RUI, so release on the investigation, for like a really long time. But that does happen. We have in our case law, but also amongst all the lawyers, we have cases where children are released on the investigation. So that means you're initially arrested for an offense, you are interviewed, and then you can either be bailed, but there are limits to how many times you can renew bail. So what we've noticed is that a lot of children are released on the investigation pending a decision on the outcome of the case, and that can take up to 2 years. But in that 2 years, or a year or 6 months, what can happen is that a child can turn 18, and that is a really significant age threshold for children. So firstly, like I was in the issue, in the theme of disproportionality, we know that children and BAME are already disproportionately impacted, but then if you also do happen to turn 18 whilst your matter are pending, that is another, that's another level of disproportionality. And there are a lot of a variety of measures that are available to children that would not be available to adults. So for example, there is a presumption of diversion for children, and you can, and this is along the theme of custody being as a last resort. So quite often, a child that has a first-time contact with the criminal justice system, you will look into giving them an out-of-court disposal. And sometimes, I'm sure quite a few of you are familiar with caution, but there are actually quite other ones that people are not familiar with, such as a community resolution, or such as the matter being recorded in an outcome that doesn't show up in the criminal record. So all of that is no longer available. And that's even if you do turn 18, but the offense you committed was actually when you were still a child. And then the youth support when you're a child, when you're under 18, is completely different, like the supervision requirement and so on, than when you turn 18. And most significantly, adult courts. So adult courts, once you turn 18, so if the first time you go to court, you've already turned 18, it doesn't matter whether you committed the offense when you were still a child, you have to go to an adult court. And that is a huge detriment to, to everyone really, but especially to children who did something when they were really young, but also because adult court, for example, have a public gallery, so anyone can come and look at you. But at the same time, children court, for example, there is no need to wear the wig, and actually the layout, the physical layout of a child court is much different of a youth court than that of an adult court. So all of that, and I'm not thinking about children and adults here, I'm also thinking about young people who have autism or who have special educational needs, who actually having that different layout would make a significant difference. Of course, you can request for those special measure, but then that's another layer. And then, just second to last, adult sentences. So, for example, if a child, even if you commit quite a serious offense, and is your first offense and you plead guilty at the first opportunity, you're likely to get referral order. That's no longer available once you become an adult. And of course, there is consideration of the age you were at when you committed the offense, but still you're no longer entitled to youth sentences. And lastly, the loss of anonymity. And this is especially important for children who commit certain type of offenses, especially of a sexual nature, which is not particularly grave per se, but there is this, we all know there is a huge stigmatization of anything that has to do with sexual offenses. So the fact that the media could report that, even though it's something you did when you were a child, is, you know, is outrageous. And I'm quickly going to, you know, talk about video links, hearing. So one of the things that we've noticed, talking about the legal ramification of COVID, is the increase in the use of video links. Whilst I appreciate not everyone may necessarily have a position on this, you know, but there are considerations to be made. For example, there is a risk in the use of video links, especially in light of what many of our government officials have been saying, which is to keep this mode because it's actually efficient. But, you know, the youth justice system is not about efficiency. It's about right. Everyone actually has a right to fair trial, but especially for children, young people, there has to be an ability to effectively participate. And there's been so much research to prove that actually the more a child and a young person participate and engage in the criminal proceeding, the more they can understand the outcome, they can relate to the sentence, and they can move on with their life. But also, like, you know, speaking to someone video links, and, you know, even now lately police station interview have been via video link. And of course there is the risk of COVID, and we have been campaigning about people not going physically to the police station, but there is a difference between having temporary measure and permanent measure. And the rapport you can build, not just with your lawyer, but let's say with the youth offending team, with the speech and language therapist, is just, or even with the judge himself, is just impeded by, you know, by the screen. And also, and so what, you know, what I think people should be aware of, if you are in the youth offending service or anything, yes, at the moment that's the default position, but if you do feel that, you know, that should not be a default position, do look at the individual case that you have in front of you and do make a case. Of course, there are many cases where it's just an administrative matter. So for example, you know, it's just to adjourn or anything of that nature, and that it does make sense for it to be by video link. But if the young person has to give evidence, it's just ridiculous to imagine that you could have, you know, their lawyer in a different room, the young person in a different room, possibly their parents in a different room. You know, that just doesn't seem like something that should remain permanently. So yes, I'm just going to try and wrap up so that there is enough time for Q&A. But you know, when I say speak to your lawyer, I mean this for young people who are listening, but I also mean this for like parents. Like right now, recently, already 3 months ago now, but there was something that was released, which is called the Coronavirus Interim CPS Guidance, which effectively clarifies prosecutor review responsibility under the code. And I think the bottom line is children generally should not be arrested for minor offenses, but they are, and quite often they end up in the system, and there are delays that are being caused, and there are risks around children turning 18. So use this as an opportunity, if you can, to reach out to your child lawyer or your client's lawyer and ask them to use this opportunity to ask for the matter to be reviewed, because there are so many cases that are actually really minor, and this could be a really good opportunity to have those cases reviewed, because that is a commitment that is not really advertised, but that was made, which was to review and not to prosecute on minor offenses. I'm just going to stop here, bearing in mind of time. But by all means, please do feel free to type your question or ask me any question you have. Thank you.
That was amazing. That is so helpful. I mean, there's so much information which
Yeah.
I had no idea about, but it's really important. So yeah, thank you so much for that. let's have a look at some of the questions. There were some questions going through, and like just to be clear, today what we're trying to do is quick, sharp information to get you going and stuff, and we're not trying to give you 4-hour lectures and stuff. But there's been some questions which have come through. I'm just going to scroll up to the top. Are any of these new laws going to affect human rights? Will or does it affect our human rights?
Yeah, of course, of course. And I think, you know, sadly, a lot of lawyers have been doing a lot of reactive work because there's just been so much. Even, for example, the regulation initially, they were passed so to last for 2 years, but a lot of people had to campaign so that that would be reduced into 6 months. There are a lot of human rights implications that are, you know, coming out of violation during this period. So if you do have any concern, do raise it. There are a lot of, if he specifically relates to action against the police or something that the police has done and you feel like it was a bit unjust, maybe the way they dealt with something, do reach out to an action against the police lawyer. It's different than a criminal lawyer, but you know, there is legal aid for it. And you know, I think no one's rights should be violated right now, but I think we all need to be careful not to be and just accept what's being like imposed on us, and our rights, our human rights, stand exactly as they are.
I think that's a really good summary, because I think what I'm definitely seeing locally is, and we're probably seeing it on social media a lot, police, which are probably more the TSG, like the territorial guys who are coming into inner city areas. And those tend to be the ones who don't know about the community makeup, who seem to be causing like a little bit of unrest and conflict within the community. So I think your point about if there's something which isn't feeling right, that, you know, make the appropriate complaints is a really, really good one. Amelia says, would really like to know in particular around the use of tasering and split hoods for Black children in particular. I think it's really important to distinguish between Black children and other ethnic minority groups. I don't know if you've got any breakdown on that, or just, I mean...
I have more than a breakdown. I have a whole report about it.
Oh my goodness,
Yeah,
okay.
yeah. So because and that's, I think, what I wouldn't use it as a momentum, but I think what really I am experiencing as a lawyer is that all these issues were already there, but now because of all this like massive disruption is all just coming out, but it's always been there. So we did write a report. I will share this, you know, with Ben, but equally you can go to our website. If you go to the Youth Justice Legal Center, there is a lot of resources, and for including our briefing on taser and spit hoods used on children and young people.
That's really helpful. And if you, I'm gonna, if you don't mind, I'd love to send your presentation out to everybody, and
Yeah.
also I'll attach that link as well. Question from Pam: how can DBS checks be challenged when offences have been done as a young person, but are completely in the past? I mean, this is a great question, because there's people who I know who are a lot older than me, in their 50s and 60s, who are unable to do youth work for very minor offence, which happened back in the day. And I suppose there's a two-pronged question here. I've got another one to add on to this. So one is, yeah, how can that be challenged, which is a great one. Is there also anything, what we're seeing with obviously the Black Lives Matter protests? One of the concerns I have is that
Yeah.
more young people are getting caught up in this stuff. Do you see like an increased risk of those young people being targeted, being done for minor offences, and they have no idea kind of how that can impact them later on in life? Is that something you're seeing or has come through?
I think that this question is really bang on, like, and I think that's what I was trying to start with, is that actually what we're saying is that there are not a lot of, I think we made a request to the Met Detention like last week, and they confirmed that there'd been 31 charges so far relating to COVID on children, relating to breach of COVID regulation and act. But what we know is that a lot of young people are being stopped on that basis, but then they're ending up with possession of cannabis and, assault on a police officer. We had a black young person who was actually, stopped on the basis of code regulation. Then when he was searched, he actually said something that was not appropriate to the police officer, but then he was charged with racially aggravated assault for he obviously, it's just like, this is how bizarre. And actually being charged with something like that is really serious, especially because that could be, spitting on someone. Assault is actually really wide ranging, but actually all he said was use a word I'm not going to repeat, but that, is just the word. So that's, and in terms of DBS, definitely a lot of people don't know this, but you don't challenge per se the DBS, but what you can do is to ask for your criminal record to be removed. And this is something that, please do reach out. We are really happy to help with this. We're actually setting up a team. One of our lawyers just qualified to actually help specifically with this. It's a very, it's a legal process, but I'm happy to share the advice on it. But effectively, there are two ways your information can be recorded. If you have a caution or a conditional caution, it goes on the police national computer, and there is one way to have that removed, which is by going online. You just go to the ACPO website, and you can then make a subject access request to see exactly what you have on your record, and then you can write to the police force that issued that to ask that to be removed. But if it's something minor, which is another thing that obviously is not as serious, but quite often people do something and then they're told, oh, it's NFA'd, but then somehow it still comes up. So especially if you have anything, and NFA means no further action has been taken, you can, that means it is recorded on the police national database, and you can, again, there is a procedure by writing to the chief constable of that specific police station to have that removed. And it is daunting, but it is something that I advise all my clients, once the matter is concluded, to have removed, because you never know.
Yeah, that's really helpful. John from Redthread, is there a mechanism to challenge RUIs which last a long time and are hanging over young people, potentially causing mental distress?
There isn't such a mechanism as such, but if you the page that is actually screening right now, it is for the CPS, but you can use it, and we have been using it as a basis to ask for them to review the cases, because the thing about RUI, you bang on, it really causes significant mental distress to young people, and normally there isn't really a basis to ask for it to be reviewed, because what the police tells you is that, oh, it just takes long. But actually now you can say, oh, don't you have better things to do like COVID? So that's how we're going about it. But specifically with regards to RUI, the parliament is actually talking about it right now. We made submission 2 weeks ago about changing this. And obviously, our government is what it is, and the parliament is doing its best. But what I'm just trying to get to is that there are some topics that are not even within the realm of parliament, but this is one that they've actually done a review for. And just yesterday, for example, they had a session on this. So it is something that has been is being discussed. So we are hoping that something will be done about it.
Really helpful. Hello, this is from Hannah. Please could you let us know the source for those statistics you refer to regarding those recorded incidents with tasers were used with children? She completely agrees. There is no circumstances where tasers should be used with children at all. Source of those statistics? I don't know if you...
Yeah, my brain. No, I'm joking. Absolutely. There are source for them, and it will be in the briefing, which I will share with Ben. But also, as an organization, we do many FOIs. But once we do a freedom of information request, they go online. So even if it's our own source, you can then go directly to the link of the response from the relevant police force.
Excellent. 10 police officers entered the property to search and did not adhere to social distancing within the property and amongst family members. Any advice? Parent has complained. Should officers adhere to social distancing when entered the property? This is a really great question, because what I've seen locally and what I've seen online, I rarely see police officers with masks or keeping social distancing. So what's your view on that? And just, should they be doing that? Is there any like legal kind of need for them to be doing that?
I think, you know, we could be here for a couple of hours when we talk about the legal need of certain behavior by the police. Um, you know, they really shouldn't be doing that. Also, I think you can really question the necessity of 10 police officers entering a house. And I think, you know, if we're keeping it in team and Black Lives Matter, like, I mean, I don't want to make any assumption here, but we have had cases where we have a number of police officers entering into the houses of Black communities. And I think they wouldn't have done that if it was maybe a different community, but that's just my opinion. So what I do think is that whilst I appreciate people have so much to get on with their life, you know, that is something that I would, you know, you can make a complaint about it, although complaint is a very long process, but I do think you should always make complaint about things. But you can even take a step farther and do speak to an action against police lawyer, because even though it does feel like something minor, it is about the people like amongst us who take that time to just like take that extra step that actually make the difference for everyone.
Really helpful. What was the heading of the session that was held yesterday in Parliament on the topic?
It was a Justice Select Committee, and if you go on Parliament TV, and it was at 2:35 yesterday. If you just go Parliament TV, you can just go back to the date. It's really well organized, and then you can listen to it. And we ourselves are giving evidence on the 30th of June. But yeah, I mean, there were different things that were discussed, but there were quite a lot of child rights activists talking about, you know, bail disproportionality. And interestingly, the issue of age of criminal responsibility also came up.
Excellent. And then the last question, what can be done in regards to young people not wearing face masks on public transport?
So that's a good question. I wouldn't know the answer, and frankly, I do think that's something that is going to stay for quite some time. So I think what I would advise for now is to read the regulation. In my slide notes there, and there is a link to the actual regulation, and just make sure that when you're reading the regulation, you're actually like there is on the left there is either a original version or updated version. So just make sure with this COVID regulation that you're clicking on the updated version, because they change every 2 weeks. But just maybe read it, and it might be that actually there is a basis for your young person not to be wearing a face mask. So for example, not many people know this, but children under 11 don't have to wear the face mask.
Okay, that's really helpful. Thank you so much. I've just put up a screen which tells people about what's coming up. So this conference is going over 3 days, and the next one is next Thursday, the 25th of June, where we're going to have actually 3 sessions. So we've got how to engage with young people virtually. That's 2 p.m. with Laura Price and Abby Ander. 3:15, gender, young people and COVID. Ebenita, Talia and Laura, again, 3 women who just really do understand the issues of young people, particularly young women, from brilliant organizations. Then at 4:30, we've got partnership working during COVID with myself, Andre Harriet from the Liminality Group, and Derek Bardwell, and Lib Peck, who is the director of the Violence Reduction Unit. So if you've already signed up, you will get the link sent to you 2 hours beforehand, and 10 minutes beforehand, just in case you miss it. And people can still sign up for those ones. So that's that there. I just want to say again, thank you so much, Augusta. I think what you've brought to the table is just incredible knowledge, and we just want to thank you so much. I really want to encourage people to if they've got issues around young people and anything legal, what Just for Kids Law do and what they bring to the table is second to none. So I'd encourage people to do that. We will send out the PowerPoint and also the links which Augusta has said in this presentation. But thank you so much for your time, Augusta.
Thank you very much. And just to conclude, I just want to say that, you know, we are also a charity and we are here to help. Like, do not keep the question in your head. Like, we're only a phone call and email away. So please do reach out.
Definitely support them financially and support Power to Fight as well, so we can continue to do our work. Thank you so much, everybody. I hope you've all had a great time. We're going to close there. We're 2 minutes over. We tried to keep the time. Please, this will be available on YouTube within the next half an hour. So please share the link at Power to Fight UK on Twitter and Instagram and Facebook. I can't remember the Just for Kids Law, but I'm sure it's just for Kids Law on Twitter. I'm sure you'll find it. So make sure you share that, and hopefully we'll see some of you guys next week. God bless. Thank you very much.